Hi everybody, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and today's contract tip is all about the 8-day unilateral extension of the closing date. Now, this is a provision that is only available to buyers and sellers who are binding under the Georgia Association of Realtors or GAR contract form. So let's talk about this a little bit. So first of all, in the GAR purchase and sale agreement, and that is GAR, Georgia Association of Realtors Form F201, and it clearly states under paragraph B4A, under closing date and possession, right to extend the closing date. The buyer and seller may unilaterally means what? Yes, one signature required. Unilaterally extend the closing date for 8 days, and since it doesn't say banking days or business days, that means 8 calendar days, upon notice to the other party given prior to or on the date of closing, which would mean the original or amended original closing date. Now there are certain specific reasons that a party may unilaterally extend the closing for 8 days. Now here are the reasons outlined. Number one, seller cannot satisfy valid title objections, excluding title objections that can be satisfied through the payment of money or by bonding off of the same, and that do not prevent the seller from conveying good and marketable title as that term is defined in the purchase and sale agreement. In other words, if there's a title issue, but that title issue is a lien on the property that can be satisfied financially, that is not a reason to use the unilateral 8-day extension. Number two, if the buyer's mortgage lender, even in an all-cash transaction where the buyer is obtaining a mortgage or a loan, or the closing attorney is delayed and cannot fulfill their respective obligations by the date of closing, as long as, provided that that delay is not caused by the buyer. Number three, the buyer has not received the required estimates or disclosures, and those are referring to the TRID disclosures, which is the Truth in Lending RESPA Integrated disclosures that a lender must disclose to a buyer 3 days prior to closing, or it is federal regulation they cannot close, and the buyer is prohibited from closing under federal regulations. So those are the specific reasons under which a party can use the unilateral right to extend the closing for 8 days. Then it states that the party unilaterally extending the closing date shall state the basis for the delay in the notice. If the right to unilaterally extend is exercised once by either buyer or seller, the right thereafter shall be terminated. So a couple of points. Number one, it must be for a specific reason. The second point is it can only be used one time per party. It can only be used one time, not per party. I take that back. It can only be used one time per transaction, period, end of story. Now, it doesn't say that only a seller may use the unilateral extension for a title issue and only the buyer may use the extension for a lending issue. Either party may use it for any one of those outlined reasons, but once it's used, it may only be used one time per transaction. Now, the other thing it says, even in an lender issue, even in an all-cash transaction. So I just wanted to point out to you that in the all-cash GAR exhibit, the other label for that is all cash or no financing contingency. In that exhibit, it does allow for a buyer to get a loan either from an institutional mortgage or from a non-institutional mortgage, like a hard money loan. And there is a provision that the parties agree either the 8-day unilateral extension shall be in full force and effect or shall not be in full force and effect. So even though a buyer is potentially getting a loan, they're just not making the contract contingent upon that loan. And that's outlined in the all cash exhibit. Another place where this is addressed in the GAR contract forms is in the amendment to extend the closing date. An amendment means there's agreement between the buyer and the seller, and it's signed by the buyer and the seller. There is a provision that the parties agree this provision to utilize the 8-day unilateral extension is still intact or is not still intact. So those are three places in the contract that it is addressed, may only be used for those specific reasons. Now, it is only a provision for the GAR, Georgia Association of Realtors, purchase and sale agreement. This is not a provision if the buyer and the seller are binding on another form. If the buyer and the seller are binding on the RE contract forms, there's not an 8-day unilateral right to extend. If buyer and seller are binding on a HUD contract, there's not an 8-day unilateral right to unilaterally extend the contract. It's not provided for in a new construction contract, in an attorney written contract, in an investor contract. So it is only a provision in the GAR purchase and sale agreement that the parties agree to when they sign that contract, unless they write a special stipulation that negates that right to use it in the GAR contract. It has nothing to do with Georgia law. It is just a contract provision that the parties agree to when they sign the contract and don't address it in an amendment or in a special stipulation. The other thing is it must be exercised prior to or at whatever the last contractual closing date is. And it extends it. So if, let's say we're closing on, let's say a closing date is set for August 9th, and one of the parties wants to use the 8-day unilateral extension, and they send that unilateral notice to the other party on August 6th. The 8 days still counts from the contractual date of closing. So regardless of when that notice is sent, as long as it is sent prior to closing, the 8-day time frame starts from the day of closing, not from when the notice is sent. Now, one of the issues to consider is the TRID regulations, the federal regulations regarding the truth in lending RESPA integrated disclosures that a lender must send to a buyer, or else it is prohibited by federal regulations from them closing. So how is this addressed in the RE forms contract? Because there's no right to unilaterally extend. So let me bring to your attention that in the standard terms of the RE forms contract, under paragraph 6.3, where it talks about the financing contingency, there's not a unilateral right to extend, but it's in paragraph 6.3.2. And this is in the standard terms of the RE forms contract. And what it states is if Fannie Mae, Freddie Mac, FHA, USDA, or VA underwriting guidelines mandate compliance with an underwriting criteria that is expressly contrary to the provisions of the contract, then those underwriting provisions shall prevail and be binding upon the parties, provided that if any of the guidelines result in an increase in cost or expense to the seller or affect the closing date. So in other words, if a lender has not yet sent out a TRID guideline, the TRID disclosures to a buyer, that's going to affect the closing date because they're federally prohibited from closing. So that would be a specific situation where it is affecting the closing date. Then the seller, at the seller's sole discretion, shall have the right to unilaterally terminate the contract. Not extend the contract, but terminate the contract within 3 days of the seller's receipt of notice of the written notice of the applicability of the guideline. In such event, the seller may terminate the contract by delivering written notice of the termination to the buyer, which termination shall thereby release both buyer and the seller from further obligations and responsibilities to one another. If the seller does not terminate the contract, then the seller is deemed to consent to those changes that are mandated by the underwriting guidelines. So, in essence, what all that means is if you're working with a buyer and the buyer finds out that they can't close on the closing date because of an issue that's going to delay closing. Specifically, the TRID disclosures have not been sent out. The first thing that has to happen is the buyer must send a notice to the seller. Now, again, we've talked about this under notice. It's not agent-to-agent email communication. This must be a notification form signed by the buyer, sent to the seller via the agents, but it must be signed in writing and signed by the buyer, stating that we cannot close on the closing date. Instead of closing on August 9th, we will need to close on August 15th. I'm just pulling these dates out of the air for an example. So, number one, the buyer has to send a notice to the seller that based on delay in closing because of an underwriting criteria, i.e. the TRID guidelines haven't, TRID disclosures haven't been sent, we can't close on this date, but we may close on that date. At that point, the seller, at the seller's sole discretion, has the right to unilaterally terminate the contract. The seller only has 3 days to terminate the contract. If the seller does not send a notice, and again, this must be a notice or notification form signed by the seller, sent to the buyer, saying, I'm terminating, and they would terminate, buyer would get their earnest money back, and everybody would go on. If the seller does not terminate within 3 days of receiving the new date of closing based on the TRID delay, then the seller agrees that, no, we're going to go ahead and close on the date that came forth in the notice. So, regarding any other contract where this issue is not addressed, any change in a closing date must be addressed by an amendment signed by both the buyer and the seller. One thing also, point of practice, if you're working with a buyer and a seller and you're binding on the GAR contract, if a closing date does need to be extended, the better option is to extend by an amendment, get both parties' agreement prior to using the 8-day unilateral extension for a couple of reasons. Number one is the 8-day unilateral extension in the GAR contract may only be used one time per contract. The second reason is if you have to use that, one party is being forced to stay in the contract against their will. Why do I say against their will? Because if they agreed to it, then it would be extended by an amendment where they signed and agreed to it. As you guys know, for a buyer and a seller moving, there are a lot of other things outside of the contract that have to happen. Movers have to be hired. Utilities need to be arranged for. There could be an issue where you have to address pets and taking care of the pets or children or so forth and so on. So there's a lot involved in moving, in buying and selling a house and actually moving. So if there's going to be a change in the agreed upon closing date, you would want to get agreement between the buyer and the seller on an amendment so that all those other arrangements can be addressed and accounted for and made versus having to use the 8-day unilateral extension. Nevertheless, in the GAR contract, that provision is there if the buyer and the seller agree to it by not addressing it in a special SIP or an amendment. I think that's it. Thank you guys so much for watching. Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.